You're watching Education for Health Professional Regulators of Ontario, colleges under the Regulated Health Professions Act. Richard Steinica is a senior partner of Steinica Mikura LeBlanc, and he practices exclusively in the area of professional regulation. Richard is the noted author of the Complete Guide to the Regulated Health Professions Act, which, because of its comprehensive nature, has been cited by courts and tribunals, even in cases dealing with non-health professions. Marshall Molesky is the past president of the Federation of Health Regulatory Colleges of Ontario, and he serves as Chief Executive Officer and Registrar of the Ontario College of Pharmacists. Join Marshall and Richard now as Marshall poses a number of important questions on behalf of those of us who want to know more about regulating healthcare practitioners in Ontario.
Would you agree that making regulations, bylaws, and standards of practice is a crucial function of the Council of College?
Absolutely, Marshall. The regulations, bylaws, and standards that are developed by Council are relied upon by practitioners in their day-to-day practice, by public members, by the public to know what to expect of practitioners, by staff as they administer the legislation. So it's absolutely essential that it be done well. And once you have given away something, it's very hard to take it back. So if you were to say, we're no longer going to view this activity, like getting a benefit from a supplier to your patients, as a conflict of interest, it's very hard to take that back.
What tips can you offer to council members when making a regulation, bylaw, or standard of practice?
Well, the council has to ensure that it has adequate information. They have to know why there's a need for this provision in the first place. What's the context? What's happening now? What's being dealt with? How is this issue being dealt with in other professions, in other jurisdictions? What are the options we have for addressing this issue? What's the public interest rationale for those various options? What are the implications? What could unexpectedly occur if we make this particular policy? And how are we going to implement it once it's done? And you would apply risk management principles to that discussion. Another thing that you would want to do is you want to review the materials in advance. You want to consider it a few times. You want to have a healthy discussion. You don't want to just say, hey, everyone approve this, okay. You want to actually discuss all those things that I just mentioned. You want to make sure you're covering the issues thoroughly, and that the decision is being made on the issues, not about individuals. And you want to listen to others and have an open mind and hear everyone while the discussion is taking place. You also want to avoid extraneous influences, especially if those are not in public. For example, any kind of lobbying by a stakeholder group. You want to make sure that all the information is being supplied in a transparent fashion from all stakeholders. You want to make a very clear decision. Everyone understands the wording. You don't want to draft these things, redraft amendments on the fly. You want to ensure there's a clear result. If you need to defer the discussion, you want to do so wisely and not just because it's challenging. And you want to have a built-in mechanism to review the decision in a year or two to see if it's working.
So what's the process for making the regulations?
A regulation usually is reviewed by council first and then is circulated to the profession and the general public for comment and discussion. Council will then review those comments and will enact the regulation in a recorded vote so the ministry knows how everyone voted. The Ministry of Health will then conduct a policy and legal review of the draft regulation. Often this involves numerous questions. Legislative Council will then review the document and will draft it in formal legal language. Cabinet will review and approve the provision, the regulation, and then it will be published in the Ontario Gazette as law.
How does the making of a bylaw by council differ from the making of a regulation?
There are some features that are the same. Council reviews and usually circulates the profession for comments, although not every bylaw requires circulation and is approved by the council. The main difference is that it does not have to go through the ministry for approval. It is in effect as soon as you publish it to the profession after having been passed by council. So that's the main difference.
Are there any formal rules for making a standard of practice or other types of policies?
No, there isn't. There's no set process. I think it is common, though, to, first of all, have a discussion about the issue, identify the issue, research it, perhaps have a discussion paper prepared by staff. You would typically discuss this at council more than once. And if it's an important document, you probably would have some consultation, and you would have a final council debate and decision on it.
Almost by definition, a regulation, a bylaw, standard of practice involve competing considerations. How can a council member appropriately balance those considerations?
I think the best way to do that is to ask yourself a number of questions as you're debating the issue. What would your thoughtful patient or client say about this? What would the minister say about this? What would the media say about it if they were reporting on it? What will the courts say if it's challenged there? Is there any hidden agenda that's behind this discussion? Will there be any unanticipated consequences as a result of this decision? And at the end of the day, what is the public interest here?
Thank you.